Good evening, everyone. Welcome to Community Conversations. I'm Dr. Heather Howard. I'm assistant professor at the Phyllis and Harvey Sandler School of Social Work. The school is housed within the College of Social Work and Criminal Justice at Florida Atlantic University. And the community is gathered here tonight. It's comprised of students and faculty, staff, administrators, special guests, and friends of FAU, campus partners, and engaged community members. We are so grateful that you have chosen to spend the next hour with us. Our college launched this conversation series as a space to learn, discuss, and explore issues affecting our local communities, with a particular focus on where the professions of social work and criminal justice intersect. The College of Social Work and Criminal Justice is uniquely positioned to host these impactful conversations because of our mission. We're striving to build a more just, resilient, and equitable society. We are change makers and innovators serving the public good by working across our professions and deeply within our communities. This is why we're here tonight. A few housekeeping notes, though, before we get started. First, we intend for this to be a conversation, and we want to hear from you. So please post your comments in the chat box, and we will respond to as many possible during the Q&A. Just before you hear from our panelists and right before the Q&A begins, we will share a link for a quick survey. Please complete it. Your feedback is important for future events like this. And finally, if you're a licensed mental health professional or nurse and earning a CEU credit for attendance, thank you for being here and for all that you do in our communities. Also, we will need your survey response to generate your CEU certificate. You'll expect to receive your certificate within 10 business days. So now I'm excited to introduce to you our panelists. Not only are they have so much information they're going to be shared tonight and have so much knowledge in this topic, but they're wonderful human beings that are dear to me. So I'm excited to introduce to you first Sharon Burns-Carter, CAC. She's in long-term recovery from substance use and is a recovering family member. In 1998, she co-founded Wellness Resource Center, a quote-unquote dual diagnosis behavioral health facility in Boca Raton, Florida. Today, she's honored to facilitate the experiential group there in her role as a consultant. Sharon's focus is on innovative transitional protocols for clients and families throughout the continuum of care for substance use and related issues. In addition to recovery management, Sharon serves with advocacy and humanitarian boards focused on recovery from substance use and family issues. She is the substance use outreach coordinator for Ruth and Norman Rales Jewish Family Services, serving South Palm Beach County to enhance resources and raise awareness for Jewish individuals, families, and the community as a whole. Next, we have Mark G. Astor. He's an attorney specializing in substance use and mental illness, born and raised in the UK until the age of 21. And you will notice still has a little bit of an accent. Mark has been an attorney since 1994 and handled thousands of cases ranging from first-degree misdemeanors to capital murder. In February 2016, Mark formed the Drug and Alcohol Attorneys, which focuses on helping families and individuals whose loved ones are suffering from substance use and mental health disorders. Mark has also litigated against many hospitals and facilities in cases where individuals are held against their will under the Baker Act and unable to secure their release. When he's not practicing law, Mark teaches Krav Maga. Awesome. The Israeli system of hand-to-hand combat taught to the military, special forces, and anti-terror units. He also enjoys early morning workouts, believing that a healthy body leads to a healthy mind. Awesome. Our third and final panelist, John Pultz. John began working with individuals suffering from substance use disorder and mental health disorders in 2013 in a support staff role. During this time, John completed his Bachelor of Social Work and Master of Social Work in May of 2017 from the Sandler School of Social Work at Florida Atlantic University. Yay! Currently, John is a licensed clinical social worker, a master certified addiction professional, and an adjunct professor at the Sandler School. John owns a private psychotherapy, crisis intervention, and case management practice located in Boca Raton, Florida. He's passionate about providing community-based services that bridge the gap from conventional treatment into the community. And he uses a firm, strength-based approach to help clients and their families achieve their goals. Super excited to hear from you. Thank you so much for being here. So I think Mr. Astor is going first, right, Mark? So you just have to unmute. Yeah. There's a little, there you go.
There we
Awesome.
go. Good job. Locked me out of mute prison. So thank you so much, Heather, and special thank you to Sharon for really being the driving force behind this. She's a truly amazing woman. I don't get a chance to say that to her very often, but now we're amongst colleagues. I'm going to tell her how grateful I am for setting this up and helping to spread the word about, you know, what we do and all the other professionals that are here, and also the folks that have taken an hour out of their dinner time to be with us. So thank you for doing that. So as Heather pointed out, I've been a lawyer since 1994. And about 7-8 years ago, I had an epiphany in terms of being a lawyer. So I'm not in recovery from substance use and mental illness. I'm actually in recovery from the legal profession. I mean, my father, before he passed away, used to tell me how much he hated all the lawyers except for me. And so I know that when people call us, it's not because they want to, and nobody wants to call a lawyer. They certainly don't want to give us any money. So so I'm always, you know, flattered and honored when a family calls us. So what we do here, a drug and alcohol attorneys, and now Baker Act attorneys too, is one thing and one thing only. We take calls from mums and dads whose loved ones are suffering from substance use, mental illness, and eating disorders. And that's all we do 7 days a week, 24 hours a day. In fact, my phone's on to 24 hours a day. And if somebody calls me, I'll always tell them, you know, I'll take the call as long as I'm awake. And so it's very rare that I wake up in the morning and don't have at least 1 or 2 messages or 1 or 2 calls that have come through the website. So just a little bit about me and how I sort of got on this path. I was a prosecutor for many years. And one of the things I noticed very early on in my career was, especially in the criminal system, was that there seemed to be the same people coming back, you know, to court all the time. So we talk about the revolving door of the emergency room. I used to see the revolving door of the courthouse, and it was people who were suffering from substance use and mental illness and just simply not getting the treatment that they needed. And of course, like any disease, it typically gets worse with time when not treated. And those folks who don't get treatment either end up, for the most part, either in the state, you know, mental health system or the state criminal justice system, or they end up dead. I mean, and that's really sort of, those are the options unless you get somebody into treatment. So, you know, if I had a nickel for every crying mother that I've spoken to, I probably would have been retired many years ago. So as a general rule, we operate in 3 arenas. Since COVID came along, I've been doing a ton of Baker Act work, people who are getting stuck in facilities, going to hospitals for issues of anxiety and depression. And the next thing you know, they're getting sucked into the state mental health system, and their families calling me to get their loved one out. And I see that not just with adults, but minor children, kids as young as 7 and 9 and 11 years old. I mean, really frightening stuff. So that is a significant part of the practice. The other half of the practice, which my partner Audra handles, has to do with Marchman and guardianship. And so what Baker Act, Marchman, and guardianship really have in common is that they're all statutes that allow for involuntary commitment. So an involuntary commitment statute means that you can be placed in treatment at the request and at the behest of somebody else. So when it comes to the Marchman Act is an involuntary statute, an involuntary commitment statute that is unique to the state of Florida. There really is nothing else quite like what we have here in Florida. I think Kentucky has Casey's Law, which is somewhat similar. But other than that, we have a very special statute in the Marchman Act. Now, when I first started to do Marchman Act work 8 years ago, it was really, I was me and then 2 other lawyers who were also doing it. And now it's sort of become the flavor of the month. So the Marchman Act is very unique in that it allows mums, dads, spouses, siblings to go to court and get a court order and make the decision to put their loved one in treatment, because it's a decision their loved one cannot make. That's the nature of the disease. Somebody who has an issue with drugs or with substance use of some form, could be alcohol, could be anything, is simply not capable of making the decision to either go into treatment, or if they can go to treatment, they're not going to stay long enough to experience that miracle of recovery that we all hope for when we send somebody to treatment. And that is the nature of the beast. And frankly, that is a significant part of the conversation I have with mums and dads. That's the hardest thing for people to understand objectively, is why is their loved one doing this? And of course, they're looking at their loved one as if, why can't you understand what you're doing to yourself? And their loved one is looking at, mom and dad, or whoever it is, the spouse, sibling, whoever it is, and saying, what the hell is the matter with you? My life is perfectly okay. This is my status quo. This is the way I choose to live my life. Too bad if you don't like it. Well, of course, they call it a family disease for a reason. It's because everybody around them is losing their mind. It's why, mom and dad are having issues in terms of, one wants to send their loved one to treatment and the other one doesn't. It's why, it's affecting everybody's ability to sleep. It's affecting relationships. It's affecting work. It's affecting everything in the family. So you've got one person in the middle of this who's dealing with a substance use and potentially co-occurring mental illness issue, and the family is falling to pieces around them. And so that's where we step in. And so I'll talk about March because that's what you want me to talk about. And I'll try and summarize it. And if you guys have questions, feel free to let me know. So Marchman Act is 2 steps, okay? And without both steps being completed, there's no treatment. So the first part of Marchman is the period of assessment and stabilization. That's part 1. And the assessment and stabilization period can be initiated one of 2 ways, either on an emergency basis or a non-emergency basis. Now, people that call us are typically calling because it's an emergency, we're the last port of call, and they want it done like right now. I mean, it's all hands on deck. And so, that's what we specialize in. So these cases come in as emergencies. And so we're going to put together with the family a petition for assessment and stabilization, and emergency ex parte order for assessment and stabilization. And what that means is that the person who's on the receiving end of this, the respondent, is not going to know about it until my private investigator, who's a retired cop, comes banging on their door with 1 or 2 police officers and said, okay, I have a court order here. You're going to a receiving facility and you don't have any choice. I have a court order here. And so that is the first part. So the statute basically requires that before any treatment can be ordered, that assessment has to be carried out, because the court is going to want to hear from somebody like a licensed clinical social worker, somebody who has the qualifications, the expertise, the training to come in and explain to the court that this person has a substance use disorder, that they present as a danger to themselves and others, and that without the order of the court, they're not going to go to treatment and address the issues that are causing them all these kinds of issues. So the petition for assessment and stabilization is normally filed within a couple hours. So it takes us a couple hours to put all the paperwork together, to sit down and get the history of what's been going on here. And just as an aside, normally these cases come to us after their loved one has been into multiple treatment centers, okay? The family has taken multiple trips to the emergency rooms for overdoses. Their loved one has probably never stayed in treatment longer than 30 days, maybe 60 at a stretch. And so the family has been dealing with this for a long, long time, and they are sick and tired of being sick and tired. And so here in Palm Beach County, we're very blessed here in Palm Beach County. So Palm Beach and Broward are probably the 2 best places to file these cases. Marion County, actually up in Ocala, happens to be a very good place to file too, but it's just a long way away for us. So Palm Beach really switched on with this stuff. So if we file a petition for assessment here in Palm Beach County, I would say normally within 2 hours, maybe 3 or 4 at a stretch, we're going to get an order from a judge telling us that the petition for assessment and stabilization has been granted. And what it will do is it will order law enforcement to go and collect that person and take them to a designated receiving facility. So, here in Palm Beach, we use a number of private facilities. There are also county facilities. As a general, we don't use them. It's not because they're no good. It's just that they're normally, filled to the brim. And, we want to make sure that we get the best result for the client. So that court order is good for 5 days, okay? So in between sort of the time of the pickup and that 5th day, we're going to file what's known as a petition for treatment services. So that is the petition. That's the document that gets us into court and gets us a hearing. Why is there a hearing? Well, because we have this little thing called due process, and the person who's on the receiving end of this, they get the right to come into court. They get the right to a lawyer. They get a right to say, Judge, there's nothing wrong with me. The allegations made by my mom and dad or my spouse or my siblings they're simply not true. And I want my day in court, and I want a lawyer, and I'm not going to treatment. So sometimes we're dealing with a time factor. So what happens if, so in not to digress, but in every county, they typically only Marchman court is on one day. In Palm Beach County, South Palm Beach County, it's Wednesday. In North Palm Beach County, it's Thursday. In Broward County, it's Tuesday. And I think in Dade, it's Friday. So every county has it on a different day. But what happens if, say, I file a case in Palm Beach County, South Palm Beach County, and I don't file it, let's say I file it on a Monday or even on a Sunday because I have access to a 24-hour filing system. Let's say I file that case on a Sunday, okay? The judge issues an order on a Monday, and they get picked up later on Monday or sometime on Tuesday. Well, that's probably not enough time for us to meet the deadline to get into court on the following Wednesday. So what happens then? How do we avoid the person getting picked up, taken to a receiving facility, held for 5 days, and then running or going and using and something terrible happening to them before we can get them into court? Well, the statute says that the court order is good for 5 days unless the petition for treatment services is filed, in which case the facility can hold them, quote, pending further order of the court, meaning I can keep them in typically for a period of 7 to 10 days. And so that's what we do. I want to go from filing the case, getting a court order, getting them picked up, taking them to a receiving facility. Then we file the petition for treatment services. And then we have a hearing. And at the hearing, we're going to decide if the person's going to go to treatment. So that assessment is typically done by somebody like John, who can give us an expert opinion as to whether or not this person meets criteria. So we're talking about somebody who has a substance use disorder. There's typically a history. They're presenting as a danger to themselves or others. If they've had a history of overdoses and haven't been able to remain in treatment, then obviously that is significant evidence of the fact that they meet criteria. So we go to court. Now, let's say they decide that they're not going to go to treatment. So we have a small trial. So here in Palm Beach and Broward, those hearings are done by what's known as a general magistrate. You can think of a magistrate as sort of a junior judge, right? They get to make rulings. They wear a robe. We call the magistrate Your Honor. And if there's going to be a hearing, which is typically anywhere from, I've had them stretch out from anywhere from 1 to 3 hours as an average, it's going to be like a small trial. It means the rules of procedure, the rules of evidence, all those fun things, they all apply, just as they would if it was a murder case or a DUI. It's the same type of thing. And so if the loved one, if say it's mom who's petitioner and their son or their daughter doesn't want to agree to treatment, then you can just imagine the scenario. We're in a very small courtroom because these things are confidential. They're not open to the public. Unlike a criminal case or even a general civil case where anybody can go and watch these things, anybody can pull the pleadings. This is a confidential procedure. It's part of the person's confidential medical file. So the idea is that nobody can go and just pull all the pleadings and take a good look at what's going on here. So there are times where I'll be sitting on the right-hand side of the courtroom if I'm petitioner's counsel. I've got mum or dad next to me, and 3 feet away from me, I have son or daughter sitting with a lawyer. Now, if they don't have the funds for a lawyer, the court's going to give them one because we're talking about taking their liberty away, so they're entitled to court-appointed counsel. And we have this whole scenario where potentially mom and dad are testifying against their son or their daughter, and at the end of the case, the magistrate is going to determine if we've proven our case by clear and convincing evidence, which is less than, say, like a criminal case, which is beyond the reasonable doubt. I always think it's sort of like 51%. So if you're going to do numbers, do math, 51%. And if we've proven our case, then they're going to be ordered into treatment. So if we don't prove our case, and every once in a while, a case goes south. Why does it go south? It could go south on a technicality. I've seen cases go south. Thank you. I've seen cases go south because, well, somebody may not have been as candid with me or may have exaggerated what was really going on. And occasionally that happens. So if the court finds that they meet criteria, they're going to be ordered into treatment for up to, not for, but up to 90 days. And that gives the treatment center the discretion, number one, how long the person stays in treatment and what level of care. So that is left up to the treatment center. I don't get to interfere in that. The judge doesn't get to interfere in that. And that is, up to the discretion of the professionals who are qualified to administer treatment. One other thing, because I know Heather's telling me I'm running out of time here. The 90 days can be extended. So if it's a 90-day court order, anytime before day 80, we can go back in and file what's known as a petition for extension. And again, that requires an assessment, typically done by somebody like John, who writes us a report and says this person needs more time in treatment, and we can go back in and ask for another 90 days. And so I will tell you from my experience, most of our cases run for about 6 months. And the reason we do 6 months is because I get a chance to talk to most of the people that I've Marchman Acted, and some of them actually refer me clients afterwards and thank me for saving them. But what they tell me is that 90 days is the absolute minimum amount of time somebody needs just for the process of recovery to begin. And so when I get calls from people who say, oh, I want to put my son or my daughter or my spouse in treatment for 30 days, I tell them, I'm not the lawyer for you, because it's simply not enough time. And if you want 30 days, you probably should call somebody else, because this is all I do. I don't do anything else. And my goal here is to save your child, your spouse, your sibling, whoever it is. I don't want, as much as I love repeat business, it sounds good, right? I don't want repeat business because it means I didn't get it right the first time. So I want to keep them there as long as possible. So Heather, thank you for allowing me to say my piece. I could probably go on for another half an hour, but I know we've got Sharon and John who are going to say their piece. And if anybody has any questions.
Yeah, thank you, Mark.
I'm always happy to talk.
There's already a few questions, so we'll save that to the end.
Right.
There's already some questions in the chat. And again, thank you so much for your devotion and dedication to these individuals and families. John, you are up.
All right, thanks, Heather and Mark. I appreciate giving the legal perspective first, and thank you guys for having me here. It's always an honor and privilege to come back to my alma mater. It's cool to be here. So I'm going to start off with one of the things that I think are the biggest controversial parts about the Marchman Act. So, social workers in the Code of Ethics, we learn, I would say probably in the DSW program, and it gets hammered home a lot, is the idea of self-determination. The way one of my professors always explained it to me was that people are allowed to make bad decisions, right? And so certainly you can look at the Marchman Act on its surface and say, well, does this ability to Marchman Act somebody into treatment, does that honor self-determination? And certainly on the surface, you can say, no, it doesn't. But what the statute of the Marchman Act is for is this person's life is at risk, they're a danger to themselves or others due to chaotic substance use, in the same way that somebody could be involuntarily hospitalized due to a Baker Act. Now, when I'm working with families and their child may be overdosing or just at risk, drinking and driving, or a spouse, they'll often say, well, can't you Baker Act them? Can't you Baker Act them? They're endangering their lives. And the response is, no, I can't. Not legally, I cannot, but this is what you can do as a legal intervention. So that's, again, the idea of self-determination. You could certainly make the argument, but these people's lives are often at risk. And that's why it's something necessary. Now, the other thing that I think the Marchman Act does well is it gets rid of this idea and this notion that people have to hit the proverbial bottom of substance use, right? So this idea that somebody must get to near death or despair, lose everything, and then on their own decide they want help. There's always been a conflicting part about this, right? On one hand, we say this is a brain, addiction is a brain disorder, substance use disorder is a brain disorder. And the same token, we say this person needs to make a really sane and logical decision to get help on their own. It doesn't align, right? So it doesn't really make a whole lot of sense. And I think people are often not able to make the decision on their own, which is why something like this is in place. And we are very unique in Florida that most states do not have this type of law. I've spoken with a lot of former clients that are out of state and families are not able to do anything. And so, one of the reasons I was really excited to do this event is that I think the Marchman Act is something that a lot of clinicians and people in Florida in general just aren't aware of, and it's an incredibly effective and useful tool. And it's really typically not used as the first line of defense. I mean, I rarely recommend a Marchman Act or get a call about a Marchman Act when it's something that this is their first time trying. So. But again, so going back to the idea of what a clinician's role and why I think it's important to educate others about the Marchman Act. So again, sometimes in private practice, or maybe it's in an agency setting, we may get somebody that is actively using substances, they're a danger to themselves. You can't really treat them in a private practice setting, and so they need inpatient treatment. And if somebody refuses, then they're kind of just left on their own. So going back into it, so how this can work in a crisis intervention model, right? So I work from an intervention model called Love First. And basically what that means is that you use love first to intervene on a loved one's substance use disorder. And so that goes away from this idea of this like hardcore confrontational model. But what's good about the Marchman Act is this can be a good plan to do in conjunction with an intervention. And like Mark said, typically when I've recommended it before, I've utilized ex parte, which is the emergency assessment for stabilization, in conjunction with a traditional intervention. And basically what I've done in that case is that, I'll come to the home, either with or without law enforcement, explain to the client what's going on, what's happening. And then often they'll decide, they don't need to be escorted by law enforcement. So that doesn't need to be that way. They can, go in, with myself transporting them. And that's what I've done as well. Now, after they get to the detox receiving facility, and like Mark said, this could be it could be a private facility, or it could be, something like the Drug Abuse Foundation. But, there's often like barriers there. For example, I had a client who, the family did not, they didn't have the means to go into a private facility. And this person ended up being on a waiting list for, I think, almost 2 months via Marchman Act to be able to get into DAF. And so during that time, they were still using. But with that being said, so they go to an assessment place, and then they go to a stabilization facility, detox receiving center, and they need to be assessed. And how they're assessed is through what's called ASAM criteria. And ASAM stands for the American Society for Addiction Medicine, and that is considered best practice in determining levels of care and treatment placement. So by levels of care, I mean residential treatment, PHP or day-night treatment, intensive outpatient treatment, and even potentially sober living as well. And so what ASAM criteria is based off of is 6 different dimensions. And those 6 dimensions are what determine where they go in. So dimension 1 is acute intoxication or withdrawal potential. So basically that's mostly related to medical. So what type of withdrawal is this person experiencing? What are they withdrawing from? And then the next part is biomedical conditions and complications. So do they have any biomedical conditions, either related or unrelated to their alcoholism or addiction? And how does this impact their ability to enter into recovery due to their substance use disorder? The third dimension is emotional, behavioral, and cognitive complications. So what this looks like is, what co-occurring mental health disorders do they have? So what I've worked on a lot of cases where people are experiencing some type of acute psychosis or increase in bipolar symptoms, mania, or depression related to cannabis use. So you want to kind of tie into how the substance use impacts the emotional behavioral conditions. And then dimension 4, so readiness to change. What is this person's motivation level? Where are they in the stages of change? Are they in pre-contemplation, contemplation, preparation, action? And most of the time, if an individual is under a Marchman Act and has been ordered for emergency assessment and stabilization, they are in pre-contemplation. So you're getting somebody involved in services at the pre-contemplation stage. That can be a difficult thing to navigate. And then dimension 5, so relapse or continued use potential. So when you look at dimension 5, you're going to say, okay, how many treatment facilities have they been in? Were they recently in a treatment facility and left against medical advice? How often has there been a recurrence of use after being in the facility? And the next part, and the last dimension, is dimension 6, which is recovery or living environment. So like anything, as social workers and discharge planning, you want to take a look at what is this person's home environment like? How does that potentially contribute to a recurrence of use? So for example, are they living with a spouse, significant other, family member that's actively using? Are there drugs in the house? Are the people that they're living with supportive of their substance use recovery? And often those are reasons why that can inhibit somebody being able to maintain abstinence. Now, after this is done, I will be qualified as an expert witness in court. And so what that looks like is someone like Mark or another attorney will go over qualifications, and then I'll be asked to explain why I provided a recommendation that I did. And to Mark's point, and one of the things I want to really emphasize is that there is due process with this. And thank God there is, because there are obvious ways that this could be exploited. So it's important, although frustrating at times for families and myself, depending on the case, it's really important that there is due process. And I've been involved in cases where I've been cross-examined for over an hour by opposing counsel, and or rather the petitioner's counsel, the respondent's counsel, I'm sorry. And that's all part of the way that this works. Now, in the event that they are ordered to treatment, like Mark said, it can be for a period of up to 90 days. Doesn't need to be the full length of time. And what's great is this can follow people throughout the whole continuum of care. So often people believe that, well, 90 days, that's a really long time for residential or PHP treatment, but this can follow the whole continuum of care, and it's really based on the facility's recommendations. So, for example, they could start off with 30 days of residential, 30 days of PHP, and then 30 days of IOP. Now, I've also participated in a lot of Marchman Act extensions. At least that's what I refer to them as. There may be a more technical legal term, but I just call them extensions. And you can extend it for another 3 months at a time, and that keeps somebody involved in services. One thing that we know through research is that the longer somebody is engaged in treatment and support services, the more likely they are to sustain longer recovery. The other piece to that is that in the event that there's a recurrence of use while somebody's under a Marchman Act, this is a fail-safe, right? So that if somebody does, return to active use, person knows, okay, well, I already have this Marchman Act, right? You contact, if Mark was working on the case or somebody else, and you may need to get an order for additional treatment, or often they can just enter in, voluntarily. It's a safety net for families and people suffering from substance use disorder. It truly, truly is. And I've seen time and time again, despite how initially angry they were at myself or an attorney that was facilitating this, their families certainly, especially if they had to testify against them, they often look back and recognize that they may not have had the ability to make the decision on their own, and they're certain that they wouldn't have been able to get help. So, again, I know, as social workers, the idea, at least for myself, the concept of the idea of forcing somebody to get help that they don't want, it was a difficult thing to wrap my mind around until I was confronted over and over again with seeing these families and people that were truly suffering with no other options. And so by going back to it, right, so they, it can act as a fail-safe. They have the ability to get themselves back into treatment, back into care if they need it. And really often what I've seen is sometimes this can just be an interruption to their active substance use. And the majority of the cases that I've worked on with Marchman Acts is that most of the time people do not contest it. That's been my experience. I don't know if Mark can attest to that as well, but I would say for the majority of the time, like the Marchman Acts are not contested and people ultimately accept going into treatment, and but they may not have done it otherwise. Right. And so I guess really, what I want to emphasize as much as possible is that although even with some of the ethical considerations of how a Marchman Act is used, for any clinicians working in this field, even if you don't work directly in a substance use disorder facility or in your private practice, you're going to encounter this, right? And you're going to encounter substance use disorder, and there are options for families to be able to get their loved one treatment even if they don't want it. And that shouldn't necessarily prevent them from getting it. And so, you know, if you do ever encounter that, you know, all the information about the Marchman Act is available, and, you know, it's filed per county. And, you know, I'm always happy to speak to somebody from kind of like the clinical side and how to clinically intervene and assess somebody properly for a Marchman Act. And that's really all I got. I appreciate it. Thank you.
Thank you so much, John. I think you answered some questions as you were speaking, so that was great. Sharon, are you ready?
Yes, I am. Thank you so much, Heather. And thank you, John and Mark. My name is Sharon Burns-Carter, and I am the Substance Use Outreach Coordinator for Rales Jewish Family Services. And I wanted to thank FAU School of Social Work and Criminal Justice for partnering with us. They partnered with us a couple of years ago in an educational series. So I wanted to just thank you again for partnering with Rales JFS. So I'm just going to kind of pick up where Mark and then John left off, and reiterate that nothing's going to ensure continued stability or recovery more than continued stability or recovery. So after someone has received clinical services and they're being discharged, and or their clinical services are being tapered, oftentimes what happens next is pretty risky, because they've been in a structured environment. Usually what you will find is usually people who have substance use disorder thrive in structured environments. They can do treatment. It's when they complete treatment that the problems arise. And that's when we oftentimes end up with complications, with readmissions over and over again to our primary care facilities, to the point where sometimes the drugs and alcohol aren't as much problem as the treatment admissions. People become very savvy at being taken care of, and it's very risky, because when they've completed treatment and they don't have the proper services in place where their continuing care needs are being met, they are at high risk, because their tolerance when it comes to many substances has been, has diminished, and they will go back to using what they had previously used, which at that point might be lethal. So having completed the clinical model, and once again, there's kind of an overlay. It's a fluid, hopefully a fluid, continuum of care. So someone might be residing in a recovery residence and continuing to receive intensive outpatient services. So the clinical services are being tapered, but there is a period of adjustment, usually a couple of weeks before people leaving treatment can kind of get their footing in the community. And what we have, and this is the social model. That was the clinical model, and you might even say that Mark's work is the legal model, clinical model, and now we're moving into the social model, which also can be under the Marchman Act. So someone can complete treatment and be compelled to reside in a recovery residence if it is the clinical recommendation. At this point, what science has borne out is that people that are entering recovery, having completed treatment, need community. Community is going to be vital when it comes to they are being able to maintain recovery. At this point, we would hope, as John had said, we would hope that they have moved into contemplation. that this isn't just someone other than themselves having a problem with their problem, that they now realize and have experienced some of the benefits of recovery, and have moved into a community, which would include a recovery residence, as well as, or maybe not a recovery residence, but definitely a mutual aid group or a pathway to recovery, where other people are in their lives and they are in the lives of people who are maintaining the same kind of lifestyle, who have experienced those things that they've experienced and have gotten through them without abusing substance or engaging in self-destructive behavior. So the goal of recovery is not to be happy or comfortable. The goal of recovery is to be able to be unhappy and uncomfortable, which life will bear, without using substances or doing anything self-destructive. So the different pathways to recovery or mutual aid groups include, there are several. Actually, there are many. They include obviously the 12-step programs. I think that that's probably the most prominent, and a lot of our clinical treatment centers, addiction treatment centers, had been based on those mutual aid groups, self-help groups. Fortunately, today, a lot of the treatment centers have moved over into a more medical model, because this is a medical condition, as well as, I believe, a mental health condition. So they have to be certified to treat people with mental health conditions. So the 12-step programs that also include 12-step programs for family members, so that when someone enters into a 12-step recovery program, family members can also get support for themselves, not necessarily to learn about the individual with the problem, but to learn how to take care of themselves, having gone through these conditions. I oftentimes say that, when it comes to a family, an individual with substance use disorder will enter treatment and stop using substances, and their needs will start getting met. However, the family, it's like an electric fan. The loved one is no longer using. However, even though the electricity isn't running, the fan is still spinning, and that could go on for years and years. So families also need mutual aid groups. So there's a 12-step programs. There's something known as SMART Recovery, which is self-management and recovery training, and that's a science-based recovery mutual aid group for people that it's kind of based in rational emotive behavioral therapy. They also have a friends and family program. There's also mutual aid groups that are based in cultural and religious bases, such as Wellbriety or White Bison. That's for Indigenous Indians, American Indians, or Celebrate Recovery is a Christian-based program. Jack's Recovery is Jewish, alcoholic, and chemically dependent and significant others. So that's for the individual and their families. That is 12-step based, but it kind of has a Jewish context to it. And then there's also secular organizations. Smart Recovery is a secular organization, but there's also SOS, which is a secular organization. In addition to that, all of these programs have virtual at this point as well. And so they can be accessed virtually, but there's also new programs that apparently people are being able to access and get into recovery through podcasts and blogs. So I know several people in Tennessee that have done that. So when someone gets out of treatment, the recommendation oftentimes is a recovery residence, here in 2-4 referred to as halfway houses or sober homes. They are certified in the state of Florida. Someone who is licensed, or an agency that's licensed to treat people for these behavioral health issues, are not allowed to refer to anything other than a certified recovery residence. That goes through the Florida Association of Recovery Residences and DCF. So their license will be impacted if they are referring to any of those residences that we are aware of and hear so much notoriety about that have engaged in those predatory practices. The difference between the recovery residence for the individual, the recovery residence, and the treatment center. So the difference between the social model and the clinical model are things like in the social model, the space that you have, your home, it's a community space that you share with your peers. In the clinical model, it's you visit your therapist or you're in a group room and it's a clinical setting or office space. In a recovery residence, you have the freedom to leave the property versus a closed campus in residential programs. Your appointments are self-scheduled, so you determine those in a treatment program. Obviously, the staff is scheduling your appointment. And most importantly, I think, is that when you are entering a recovery residence, most of the peers there, because this is a peer model, have more than 30 days of recovery. Usually that is the policy and the rules. Wherein in the community that one is part of in a treatment program, there's all different levels of care. And the problem with that is there is at any given time, there aren't any peer leaders. And when there is a peer leader, usually they are moved into a recovery residence, so they move on. In these settings, in the recovery residence, there are paraprofessionals, usually referred to as peer support specialists or sober coaches. They oftentimes, or most of the times, if they're especially a certified recovery specialist, they are in recovery, and they even be an alumni of that house or home. Finally, the space of recovery is one in which a person may access or enter into a recovery community center or recovery community organization. These are drop-in centers. Oh, there's also alternative peer groups. So recovery community centers oftentimes would be the umbrella under which recovery community centers and alternative peer groups manage. So these are social settings. And as John had alluded to, when someone leaves treatment, they are oftentimes at risk if they return to their former dwelling where there were substances or where they had triggers, quote unquote, and they were conditioned to use. This is especially the case with adolescents who have substance use issues and have to return to their old school. If they do not have an alternative peer group or wellness group, the odds of them being able to remain healthy are not very good. So when people enter into or are welcomed into a recovery community center, and I just want to give a plug because Palm Beach County has just opened over the last several months our own recovery community center, which is called the Hub, and you can find it on palmbeachcountyhub.org. We are under the guidance, I guess, of the Palm Beach County Behavioral Health Coalition at this point. And when someone would enter a recovery community center, they usually would, or at the Hub anyway, they receive a recovery capital assessment or a recovery capital scale. Sometimes it is self-administered. But what this is doing is it's kind of taking stock or inventory of what kind of recovery capital this individual has and to help them explore what their needs may be. Because at the Recovery Community Center, we are able to direct them to resources in our community where their needs may be met. This can include anything from medical managed therapy or medical managed treatment to interview skills, to having to sit on a computer and make a court hearing, to finding daycare for a mom who's in early recovery. So recovery capital is a big part of ongoing care, because somebody who has been in recovery before has made investments and deposits into their recovery, and they're much different from people who are entering recovery for the first time. So that has been an important part of being able to move, the research in recovery, reset data, and being able to develop most promising practices or best practices for people in this stage of recovery and ongoing recovery is a new science. So we're just beginning to, find those things that work best. We've been studying alcoholism and addiction for decades. We're just beginning to get the data that we need in order to come up with the best practices and the best scenarios for people that for sustainable recovery plans. And what I wanted to do at this point is also just cite William White, a PhD, who is a gentleman who resides in Naples, Florida, but he is the creme de la creme when it comes to research on recovery. He can be found on William White papers. He's a researcher. He's just does everything, knows the history of recovery, what we did, what we didn't do. And the social model is something, Bill White believes that people, just like any chronic illness, people from 1 to 5 years, if you had cancer, you would go to your doctor at 5 years to get a clean bill of health. And it is the same thing with people who have substance use disorder. And William White would even tell you it would be the same thing for the families. That 5 years out, they are at the same risk as anybody who didn't have this problem of being, of relapsing or coming out of remission. So I think that's pretty much it. I just want to be sure that my goal is to move away from the black and white thinking when it comes to this condition, especially when this condition is characterized by relapse and remission. That people who have had 14 years of recovery and experience a reoccurrence of symptoms or a relapse still had those 14 years, and they, better than anyone else, know what it is they need to do to remain in recovery. Recovery community centers are very good at taking all of that into account. And I'm really glad that we're beginning to, in Palm Beach County, we have one. We are having fun in recovery. We're having parties and Friendsgiving on November 18th. So anybody that's interested in that, we can follow up with you. As well as recovery community centers in North Palm Beach and Broward County. So thank you everybody for being here, and done.
Thank you so much, Sharon, and thank you, Mark, and thank you, John. We really appreciate you leading this important conversation. So we've had received a lot of great questions, but before we get into you all answering the questions, let's just take a moment to complete the brief survey that I spoke about in the beginning when you all arrived in the Zoom. So Ashley is now going to share that in the chat box right now, and it will take less than a minute to complete. So why don't we do that? And then we're going to get to the questions. Okay, so while people are finishing that survey, I want to try to get to as many questions as we can. The first one I may be directed to you, Mark. Does a social worker accompany the police officer to do the pickup of a person who's going to treatment for, let's say, a smoother transport and communication process? Just make sure you come out of the unmute dungeon again. Almost. Just click the that bottom. There we go. Thank you.
That's a great question. It really is. And actually, when I was listening to John and I hear this question, I'm like, that's a really good idea. But I can tell you, so in Palm Beach County, I'm able to use my own guy. So Dan is a former Palm Beach County deputy sheriff, and he goes with law enforcement to make sure things don't get out of hand, because things can get out of hand if people get crazy with the cops. They're going to find themselves in a difficult situation. And as a former prosecutor and big supporter of law enforcement, you know, these guys and girls have to make sure they're safe. If somebody has a serious issue, we can't have law enforcement being placed at risk. That being said, when I have Dan there, yeah, it really helps to diffuse the situation because he's able to keep the person calm. A lot of the agencies don't want anybody else around because they don't want anybody interfering with their ability to do their job. But I can tell you that in Delray, we have Ariana Ciancio, who is Delray Beach's in-house social worker, and she is, I mean, we need an Ariana in every police department, everywhere in the country. She's amazing. And she's really changed the whole conversation. And she's done a phenomenal job of educating the officers. But if you could have somebody like her or John, or, you know, because if you're private counsel, you can hire somebody like John at the scene, I think it's a great idea. And actually, you know, and I'm going to digress a little bit, what John talked about in terms of the intervention. So interventionists are great at getting people into treatment, and it's much less of a hammer than a Marchman Act. But the Marchman Act is great at keeping people there. So sometimes the two together are really excellent. So what John does is a really, really important piece of what we do. And I'm not a clinician, and so I rely heavily on people like John to really give me that clinical piece. So just know, for all the folks here who are either clinicians or training to be clinicians, what you do, I mean, if without the clinicians, I'm just a lawyer with a piece of paper in his hand. So know how important your work is. So sorry I digress, but it's an opportunity to tell people how important the work is.
Thank you so much. And it's wonderful, you know, seeing the interprofessional work here. So, John, this may be directed to you. You know, Mark and Sharon, you might have an opinion about it, but you had mentioned co-occurring disorders, Mark, but what is in your experience with someone that has co-occurring mental health and substance use, is this process possibly more beneficial compared to the Baker Act?
Sure. Yeah, I can definitely answer that. And also, if it's okay, just briefly touch on the question that was directed towards Mark. You know, certainly it's not, you know, absolutely necessary to have a social worker, like a therapist or an interventionist there if the law enforcement were to come pick them up. But I mean, I think it can help diffuse the situation. And that's been my experience. And again, oftentimes you're able to avoid a law enforcement, at least I have an experience with avoiding a law enforcement transport at all, if you're able to transport them yourself. But as far as, you know, the dual diagnosis component, and, you know, in order for somebody to meet there's a very, very specific criteria for somebody to meet for a Baker Act. And, you know, I've had the experience of initiating a Baker Act and then somebody is released in under 24 hours. There's often the incorrect assumption that a Baker Act is a mandatory 72-hour hold. It's an order for an assessment, and it's a 23-hour hold that has to be done. And so that is a very, very short period of time. And so, you know, I've facilitated, I would even say most Marchman Acts that I've participated in have been with a client that is more severely dually diagnosed. And I think it's rare these days, and this is an opinion that I think would be supported with research, that somebody has substance use disorder with no co-occurring mental health issues. And again, I speak a lot about this because I see it more and more, and I'm sure Mark would agree with this. Cannabis use disorder, which often is minimized as just weed or whatever else people may think of, is a severe contributor to bipolar disorder, schizophrenia, schizoaffective disorder, and including psychosis. And so often we'll see that in hand, where on the surface, somebody's substance use disorder isn't totally out of control, but it's severely impacting their mental health. And so to answer the question, yes, I've definitely seen it be effective in those cases.
Thank you, John. And I don't know if it's possible, and maybe at the end in the chat box, you had shared some resources, some in your assessments, in your clinical assessments, you know, the preparedness for change and ASAM, you know, those screening, maybe would be helpful for some of the people in the audience to have your screening tools recommendation. That would be great.
Absolutely, I can share that.
Thank you. And so a question for you, Mark. If someone is currently in Florida, but not a resident of Florida, can you utilize the Marchman Act?
Yeah, so the Marchman Act is based on where they're physically located. So I would tell you that most of our clients are actually out of state, that the parents are out of state and their loved ones are coming here for treatment. I mean, contrary to what used to be the situation here in Florida, thanks in large part to State Attorney Dave Ehrenberg and the task force, Florida has become a great place to come for treatment. There's still a great selection of really good treatment centers. So a lot of people that we work with, their loved ones are coming here for treatment, and the family wants that safety to make sure that if there's somebody's not compliant, that we can run into court. So as long as they're physically here, then the court can have jurisdiction over them. So, basically whichever county they happen to be situated in, and there are some counties that are way better than this, and there are some counties that just flat out suck at doing Marchman Acts, and I won't file a case there. As long as they're here, we got them. Doesn't matter where they're a resident of. I've had people from other countries come here. I've got a kid right now whose family's in Italy. The parents are in Italy. So.
So, and follow up with that, Mark, is there someone who kind of supervises the whole process from beginning to end to ensure successful or at least adequate rehabilitation on behalf of the family, or is the family in charge of the process?
So to a large extent, once the person's in treatment, we rely on the treatment center to a large extent to manage the care. And obviously, the whole issue, sometimes the family gets frustrated because if their loved one, as John pointed out, is really angry with them, which is, a lot of the time, they don't always want to sign a release of information. So now the family's upset because they can't find out what's really going on. And they're calling me saying, my loved one, won't sign a release of information. And I don't know what's going on. And it's all your fault. I mean, talking to me is my fault, right? But, we still have medical privilege here. So that can be a problem. So, we rely on the clinicians now. If we happen to be working with somebody like John, that really helps us tremendously, because I'm not a clinician. I don't have clinical training, and frankly, the hardest part of what we do is dealing with the family's emotional state, their emotional state, because they're emotional, right? And they're angry and they're frustrated, and they don't understand why they put their loved one is better in a week or 10 days or 30 days. So having that clinical part there really helps. So I guess it's a long-winded answer, but we try to be the go-between if we can, and we try to, I like to think we've gotten a lot better at dealing with the emotional component. But when you got somebody like John working with you hand in hand, and if the family has resources to hire somebody like John and work with us, it's a game changer. It really is. It's a game changer.
Mm-hmm.
So.
Great. Thank you, Mark. Another specific question about the Marchman Act. What happens if an individual doesn't abide by the involuntary treatment?
Yeah, so it's a court order, which means that compliance is not optional, it's mandatory. And so the sanction for that is contempt, which could end up in 5 months and 29 days in jail. Now, obviously, if the person runs out of the jurisdiction, which has happened, I had one girl who ran to Mexico twice, and we had to send the private investigator all the way to Mexico to bring her back twice. And we ultimately, got her in front of the court, and she went back into treatment. But if the person flees, then it's a problem, because it's a Florida court order, and not every other jurisdiction is going to recognize it. But the appropriate relief is contempt. I would say very few cases end up with a contempt proceeding, because most people understand first of all, they don't want to end up going to jail. But second of all, and maybe John can speak to this, but there's sort of this psychological component, because the hardest part for somebody who's got a disorder is for them to make the decision to go into treatment and stay there. Well, if a judge has made it for them, now you've removed that sort of internal conflict between their rational mind and their unconscious brain, which is sort of a conflict. One, the rational mind says, listen, we need help. The unconscious mind says, listen, we're not changing anything. This is status quo. We're not going to treatment. So when the judge makes that decision for them, it takes the pressure off. And so that's why I think most people remain compliant with the court order. Is it every case? No. Do we save everybody? No, that's just not realistic. But we save a lot of people, and the Marchman Act does a lot of great work. So you know, that have that court order hanging over the head, they know they can't leave or shouldn't leave, and very few of them do.
Thank you, Mark. Sharon, I have a question for you. Kind of just briefly, what the hub is, and I believe it's in Delray Beach, and any numbers that the audience can receive that need to access help.
Sure, I can go ahead and I'll put the website up on the in the chat. So the hub is a recovery community organization, and recovery community organization under which the hub recovery community center is. In the recovery community center, we have 2 peer support specialists. We have a pantry, we have computers, we have vocational counseling, and most importantly, I think our trained director, Ian Stone, who is a recovery community, is a peer support specialist. He's very astute. He oversees the assessment, the recovery capital assessment, and is able to work with the individual to be able to ascertain what it is that we have in our community that they may be able to access. For instance, you know, do they need a dentist? Are they struggling with that? And it could be anywhere along the continuum. In other words, people can come in needing treatment, and we will do whatever we can to direct them to that treatment. It's, you know, our center at this point we're just open, so we're just developing. And one of our missions, I don't know the mission by heart, but one of our missions is to ensure that we have a community that isn't specific to any you know, pathway to recovery. It's open to everyone and families, where we can have trainings, where and most importantly for me as a woman in long-term recovery, so that we can have fun. People need to know that they can have fun in recovery. So I will put the website up. It's on the corner of Atlantic and Congress in the shopping center.
Thank you, Sharon. Could you also put the researcher's name that you were talking about?
White? Yes.
Yes, please. People are asking about that. Now, there was another question, and John, you may be able to answer this. When people are in mandatory treatment and voluntary, are they given medication or detoxification if needed, supervision? Like, what's usually the process?
Sure, absolutely. So, I mean, I think that what's important as far as like the mandatory treatment is concerned, it's not the same, you know, you're not deemed involuntary incompetent in the same way that you could be deemed that in a Baker Act receiving facility, where conceivably you could be forced to take medication. When you're Marchman Acted involuntarily to a facility, you're Marchman Acted to the facility. You're not forced to partake in any particular therapy modality or medication. But you know, as far as what they receive, yeah, absolutely. They'll receive, if they need to go to a medical detox facility, they'll be properly detoxed in a safe and humane way, hopefully in a way that doesn't involve a lot of suffering or uncomfortability. And, you know, they will be evaluated by a psychiatrist or medical provider, like a psychiatric nurse practitioner, for co-occurring issues as well, and possibly prescribed medications for other mental health disorders throughout their whole stay there. And they receive, you know, clinical and medical support.
Excellent, thank you. We have another question about the cost, you know, of obtaining a Marchman Act, and you know, I'm assuming that this isn't a free process, and so what are your thoughts on that, Mark?
You're muted again, Mark.
There we go. Yeah, I'll tell you what it costs. And the cost to do a Marchman Act is $9,500, and that's for 3 months of representation. So it works at about $2,500 a month, and there's some costs to go along. So it's not a cheap process. It's not, and I'll be the first one to tell you that. So that's the cost.
Yeah, no, thank you. Thank you for that transparency. And I'm sure a lot of people in the audience consider, you know, the potential of positive outcomes, but it may not be available to all individuals impacted.
Let me just tell you one other thing.
Mm-hmm.
There's nothing that prevents somebody from going to the courthouse and doing this themselves. Okay.
Yeah.
I think it's a tough road to hoe. I think that understanding that there's 2 parts to this, and the first part could be an emergency or non-emergency. dealing with the hearing and dealing with opposing counsel, I think it's difficult, but it can be done. But look, I filed hundreds of these things, and the statute is complicated enough without having to deal with the other issues, like the rules of procedure and rules of evidence. And frankly, know which county you should be filing these things in. I've seen people file things in counties and then not ask for the right relief, not ask for their loved one to be taken to the right facility. They end up in somewhere completely different, and things go south very, very quickly. Or by some miracle, they get a court order, and then the loved one is treatment, and they're like, well, what do I do? Well, how do you enforce that court order? So it could be done. I think it's difficult, and maybe we could have a whole discussion about this. And I've even spoken to Dave Ehrenberg about this. That we need to provide. Look, if people who are getting Marchman Act to get a free lawyer, right, and they should do if they can't afford one, then why doesn't the family why doesn't the family have access to a lawyer who can help them to do this right, so their loved one doesn't end up dead or in prison? I mean,
Right.
And again, it comes down to money, right? I mean, I don't want to get
No, I appreciate, Mark,
those
that,
people need help, and I get it, and I do. But
yeah, I appreciate that.
Not cheap.
And I think just continuing to advocate, you mentioned at the end about family, the importance of family involvement. All three of you did.
yeah, and just for what it's worth, I put out a ton of free content on my website. I've even got a small book that tells you how to do it on both my drug and alcohol alternatives website and the Baker Act site. And I'm a big believer that, that unless someone wants to hire me, they should get the information for free, and they should get the right information for free. So, I mean, I'm always happy to give stuff away. And if somebody wants a referral to a clinician, they don't have to pay me to give them John's phone number, or Sharon's phone number. I'll give it to them. No problem.
Yeah, so please
sorry.
put your contact information, Mark, in the chat box so people want to access that information. I'm sorry, John, I didn't mean to interrupt.
No, it's okay. So yeah, just real briefly, I just want to say that certainly it's a more streamlined and easier process if you can use an attorney, if the family has the ability to do it, but it's not 100% necessary. I have worked on cases where people have just go pay $5 to get the Marchman Act packet. They spend all the time to fill it out. But again, there's so many barriers that come into play there. The time that it takes to file, if you get the court order, if they're ordered to DAF and there's no beds, they can't create a bed. So it's definitely better if you can, hire an attorney like Mark, but there are other options. So.
Sure. Well, thank you so much, Mark, John, and Sharon. I mean, most importantly, for your dedication, to individuals impacted by substance and alcohol use and their families. All three of you, I know, are so committed and dedicated, and even taking your time on an evening instead of having dinner. So really, really appreciate you all.
Thank you. We're flattered that you asked us, Heather. Thank you.
Yeah, thank you so much. So to our attendees, please mark your calendars and plan to join us for the next community conversation in the new year. It will be February 2nd, 2022. And the topic will be, quote, what's justice got to do with it, unquote, where we'll discuss tools that are needed to create change with the individual people we serve, as well as dealing with the large systemic issues and how academic and frontline workers can support each other more effectively. So thank you all. Hope to see you in February. And again, thank you to our amazing panelists. Really appreciate your time and sharing your expertise with us.
Thanks, Heather.
Thank you.
Yeah, thanks for having me. Take care.
Thank
Bye-bye.
you.
You're welcome. Bye-bye.